country from which the child has been brought and of which the child is ordinarily resident. And the sending of the child back will be a way of denying the abductor the benefits of what they have done. It will be a way of respecting the court system of the country of ordinary residence. It will be a discouragement to the practice of abduction, because in the case of children from biblical times, parents can become quite naturally motivated by love, seeing it only through their own point of view. They can become very obsessive and determined. And so the International Child Abduction Convention was designed to act quickly, send the child back, and have the courts of the place of ordinary residence determine the issues of custody and residence of the children. In order to protect countries from the fact that some other countries that might ratify the convention might be perceived by some nations as unlikely always to act in the spirit of the convention. If you sign the convention, you do not automatically undertake that you will send the child back to all countries that sign the convention. There's an extra step. You have to not only accept the convention, but you are entitled to accept or not accept the other country as a country which you agree will comply with the spirit of the convention. So there's a double check, and the double check is a protection against a matter which Justice Gummo raised in an argument in one case, that there are those countries out there where a child may not be sent back if the child is to be sent back from, as he instances, an Islamic country to a country that was non-Islamic. And there's no doubt that in the case of Malaysia and some other countries, there have been instances where a child has been brought back and the view has been taken that the child should not be sent back to Australia because in Australia the religion of the child might not be fully safeguarded. So that is the double check that is in place in respect of the Child Abduction Convention. But in the paper which I've commended to you, the 5 instances that I mentioned are all instances until the most recent case of Justice Forrest, where the High Court did not order return. And so you have to ask, why is this so? Is this an unrepresentative sample? 5 is not a very big number of cases. So in this excellent essay, which was given in honour of the late Justice Peter Nye, I looked at the statistics about return, and other tables in the document show the numbers of the percentage of cases where children have been returned in child abduction litigation. And I was rather surprised this morning reading these statistics again to see that the percentage of return, either by acquiescence or judicial order, is not as high in Australia as it is in other countries, and contrary to what I think would have been my expectation, that the percentage of returns would be something of the order of 3/4. It's, in the case of Australia, not more than 50%. Therefore, in 50% of cases of abduction, child abduction, bringing people to Australia, the abductor is rewarded, and the abductee is not given the benefit of the convention one way or the other, either through agreement of the parties in some cases, or through the court refusing return, or for the court concluding that the child wasn't ordinarily resident in the place which is a precondition to the abduction being reversed, or for some other reason, a finding of harm, considerable harm to the child by virtue of return. But the scheme is return. And if a country doesn't return, and if it becomes known that it's a non-returning country, then the likelihood is that other countries will not reciprocate. I mean, why should they? If you don't return your children to Mexico or to New Zealand, why should other countries turn your children to you? Or children who are ordinarily resident in Australia. And this is a very important matter for Australia, so far as Australia is concerned, because we are, as you know, a very multicultural country. We have, say possibly for Israel, we have more people from more countries, different countries in Australia than almost all other countries. And therefore, we've got a lot of people with a lot of children and a lot of disputes and a lot of opportunities for the operation of the International Trial Convention. Therefore, we have a stake in it. And if you have a stake in it and you want children who are seized from Australia and taken to other countries to be returned for that matter of custody and residence to be determined here, as it would ordinarily be, then you have to do the same. You have to be prepared to take part in the scheme set up by the convention. Now, if I ask myself, why did you disagree in every case? Were you just being difficult? I mean, that is a possibility. It's a possibility. Are you a contrarian about this? But in, I think, 3 of the 5 cases, Chief Justice Gleeson agreed with me. And therefore, it wasn't just disagreement, it was disagreement for a reason. And the reasons, I suppose, that affected my own approach were similar to the reasons upon which Peter Nye, as an expert in private international law and a reporter and member of a special commission of the Hague Conference, which had drafted and supervised the Child Abduction Convention, he had written, even back in 2002, which was before all of the 5 cases were decided, quote, "A regrettable departure from the general consensus underlying the Convention that the exceptions to Article 13 should be narrowly construed has become a feature of the Australian response to applications under the Convention." And he declared that Australia was continuing its march away from the international consensus on the operation of the Convention. So if I analyse, as far as I can in my own case, what my own thinking on the Convention and its application were, they were the principle of mutuality, the principle of reciprocity, the practical consideration of the fact that we are a big user of, and likely to continue to be, a big user of the Convention. The fact that if the Convention is to operate normally, the very decision of where the child should be resident is to be determined in the case from which the child was taken. And therefore, that it is alien to the scheme and purpose of the Convention to turn the consideration of exceptional grounds into a way of getting round the application of the Convention, and to have that decision, the decision of the swift decision of whether the Convention should be applied, actually turned into a custody case. That the whole point of the Convention is that that should be done in the place from which the child was abducted. And also the practical consideration that unless that is the approach that is taken by courts, you are effectively rewarding those who do abduction, and abduction is not a good look. And there's a lot of evidence, which is referred to in this paper, that it is extremely stressful to the children concerned, very divisive, that they not only have the breakdown of the human relationship with their parents, which is a devastation for many or most children who have to go through that, but they are suddenly whisked away to the other side of the world, and the ordinary crisis of resolving parental disagreements by court orders as to how you can, as best you can, rescue the children and protect the children's position.